Digital rights. Introduction. Digital rights are a collection of rights protected by law for people who create, publish, and use digital media. Creators have rights to say how their materials are used or published. Users have rights once they have purchased access to the materials, and we all have a right of privacy to our information when using the Internet. These rights are relatively new extensions of laws that already existed, like the right to privacy and the freedom of expression. Different countries have different laws about digital rights, and how these rights are protected varies as well. Intellectual property and creators. Intellectual property is another way to describe someone's creative work, like books, essays, movies, songs, photos, paintings, or the code for an application or a video game. Copyright laws give creators the right to say what is done with their intellectual property, which usually means not letting others access it for free or use it and benefit from it as though they created it. Intellectual property laws existed long before the Internet and were applied to digital work as it became necessary. In many cases, the law has not caught up with the pace of technological advancements, and so this is an ever-changing field. Intellectual property laws: copyright, trademark, and patent. There are three main types of intellectual property protected by law. Copyright. Copyright laws protect an author's creative or intellectual work, like a novel, an essay, a song, or a photograph. The creator does not have to register to get the copyright protection. It's an automatic law that applies to published work. Trademark. This is a law that helps companies distinguish their creation from the creations of competitors. It's often connected to a brand, and logos and product names are usually trademarked. For example, the Starbucks name and logo, the Twitter name and Bluebird icon, and the Nike swoosh and Just Do It tagline are all trademarked. To get a trademark, the company must apply to the government and go through a registration process. Patent. These laws protect new inventions so that others can't claim to have invented the same thing and gain financially from it. For example, whenever a pharmaceutical company creates a new drug, they patent it. That drug can't be distributed in any other form, just the name brand. But patents only last for a limited time, and once the patent is over, other companies can create the object. In the example of a new drug, once the patent period has expired, it can be made and sold as a generic form of the drug without the brand name. Why are these laws important? These laws might not seem so important if you're the person using the materials instead of the one creating them. But imagine that you spent hours and hours writing a really great essay, and then you later find out that someone copied the essay and turned it in as their own and got an A. You'd probably be pretty mad, right? Now think about how it would be if instead of an essay, it was a photograph you took, and someone turned it in as theirs to a magazine and got paid $1,000 for the work. That's even worse, right? That's why copyright laws are important. They protect your creative work, your intellectual property. And as a digital media professional in the future, you'll have work that you'll want to protect. Consequences. There are also consequences for violating intellectual property laws. When someone breaks a copyright law, it's called copyright infringement. The infringer who breaks the law, that is, the person who uses someone else's work and gains financially because of it, will be required to pay the full dollar amount of damages and profits. The infringer will also have to pay all the attorney's fees, their own and the other side's, and all court costs. The court will issue an injunction to the infringer to take down the copied material, and the infringer can also be given jail time. For example, in a famous 2019 copyright court case, Katy Perry's song Dark Horse was found by the court to contain copied portions of the musical score from a song by rapper Marcus Gray. The judge found Perry guilty and ordered her and her studio to pay $2.7 million to Gray. Plagiarism. The Perry case has to do with copyright infringement because the rapper's song had been copyrighted before Perry's song was released. A similar situation to copyright infringement is when someone uses another person's words in written form and does not give credit to the author. In other words, using someone else's words as though they are your own. You've probably heard this term before: plagiarism. While you're still in school, plagiarism is an offense that can get you a failure in the class, or worse, ejected from the school. In the professional world, it can mean the end of your career. For example, in 2006, a young Harvard student named Kavya Vishwanathan wrote a book called How Opal Mehta Got Kissed, Got Wild, and Got a Life. She got a $1 million book deal from her publisher, the book made the New York Times bestseller list, and there were rumors of a soon-to-be-made movie. But then, it was found that big sections of her book were just like someone else's book, and everything went downhill from there. Her publisher revoked her deal, and, in a move that is pretty rare in the publishing field, they pulled her book from the shelves. Intellectual property and users. On the user end, you've probably experienced intellectual property laws and didn't even know it. Because of the deep reach the internet now has into our lives, we are daily presented with the ability to copy, download, and use other people's creative work. We don't give much thought to seeing a funny meme, copying it, and posting it on our own timelines. The internet has changed a lot about how intellectual property works. Before the days of the internet, if you wanted to own an album by your favorite musician, you had to go to a physical store and buy it. But if you want to listen to your favorite musician now, you can go to an online store like Amazon, pay for the song or the album, and download it immediately. That's a great convenience thanks to the internet. We now purchase most video games this way too. Using either a computer or a console like Xbox or PlayStation, we go to an online store, purchase access, and then download. Or say you don't have the money to pay and you just search the internet to see if you can find a free download. You probably can. If you do and you download it and use it without paying, that's called piracy, a term named after pirates who brought their ship up alongside merchant ships to steal their goods. Piracy, in other words, means the unauthorized accessing and copying of someone else's work. It's usually a term used only when talking about digital materials. The changing way we access and own things like games, songs, magazines, and books is a huge issue for movie studios, publishers, and music labels. They only exist to sell access to their products, and the artists themselves can't create things for free. They have to make a living too. If an increasing number of users pirate the products from the internet, neither the companies nor the artists will be in business much longer. That's another reason you, as mostly a user right now, should observe intellectual property laws. When you do so, you are respecting the rights of the creators and allowing them to be paid for their work. Digital rights management. Content producers like film studios, game developers, and publishers have responded to the rising problem of piracy by using digital rights management (DRM) tools that restrict the way consumers can copy content they've purchased. DRM embeds code into the downloadable file to prevent making a copy, to specify a window of time in which the file can be accessed, or to limit the number of devices the file can be used on. If you've ever clicked on a link to what sounds like an interesting article and been stopped by a page that says you don't have access unless you pay a subscription, you've run into DRM code. Not everyone thinks DRM is a good idea. Those in favor say that it's difficult to catch pirates, so any technology that makes it harder for them to steal is worth it. But those who oppose DRM say that it often complicates the transaction of using the item. It makes it harder to access the site, download the game, or impossible to switch it if something happens to your console, and makes the user experience a poor one. Non-disclosure agreements. Another way that companies and organizations protect their creations is through the use of non-disclosure agreements, NDAs. These are basically contracts someone signs to say they will not disclose or talk about any information they know about that company's products or communications. If you interview with a big tech company and part of that interview is talking about a new product they haven't released yet, they'll probably ask you to sign an NDA and not talk about that product. Or, if you're working as a consultant and part of your work is to create digital media about a product, you'll also likely be asked to sign an NDA to not talk about the inner workings of the company and their product. Although they're used in specific circumstances, NDAs are really just another way to protect someone's intellectual property. Using intellectual property, fair use, Creative Commons, and open source. If you're a digital media professional, at some point you'll be in a situation where you need to use copyrighted work. If so, you can get a license to use a work or part of it, but it's not cheap. For example, if you're watching a commercial for Xfinity and in the background you hear a famous Beatles song, then you know that Xfinity paid a very hefty fee to use that song, probably $250,000 or more. Creators can sell licensing rights to their work, and these rights can be open-ended or very limited. But what if you need some music and you or your company can't pay the big licensing fees? Or what if you want to use a quotation from a copyrighted book in an essay you're writing for school? There are options. Fair use. Intellectual property laws protect creators, but the lawmakers also wanted to allow for a free flow of information to better promote the arts and sciences. So fair use laws were created that say, if you are using a portion of someone else's work, with credit given, for the purposes of criticism, comment, news reporting, teaching, scholarship, or research, it is not considered infringement. You don't have to register or apply to claim fair use of someone else's work. You just use it. However, you can't claim fair use if you are making any profit from the use of these materials. In a nutshell, that's why when you're writing an essay for school, it's okay for you to take excerpts from other people's writing and incorporate them into your own sentences. You are using the materials under the theory of fair use. You're not making any money from writing that essay, and your use of the material is for the purpose of criticizing, commenting, scholarship, or research. However, if you don't give credit to the original writer with citations, then you are committing plagiarism. Creative Commons. In the early 2000s, law professor Lawrence Lessig founded the Creative Commons nonprofit organization to work toward a more free and open flow of information on the Internet. Lessig argues that new technologies have created new genres of communicating, like a remix or a mashup. But the strictness of copyright laws makes it difficult and gives too much power to big companies because they are the ones who own most of the content. The Creative Commons organization offers pre-made licenses based on copyright laws that creators can choose to apply to their work. Basically, the creator waives the right to collect income and grants partial rights to use the work, but there are different options creators can choose concerning their limitations for how it can be used. Creative Commons makes it possible to use thousands of music clips, video clips, images, and photographs and know that you are following copyright laws. Open source. Fair use in Creative Commons can be applied to creations such as text, music, and film. Open source is the application of these ideas to computer source code. There are applications or computer languages created by a group of programmers who waived their intellectual property rights so that anyone can download, use, and even modify them. Firefox and GIMP are two examples of open source applications that were created by a group of programmers and then made openly available. Computer languages are also included. Python is an open source version of the computer language C.